Good morning, everyone, and welcome to the Lloyds Banking Group 2024 Annual General Meeting.
Ladies and gentlemen, before we get this AGM started, I want to ask the board why Lloyds is funding genocide in Palestine. Over 36,000 Palestinians...
There will be a time for questions later in the meeting. Could we please get the meeting started? Thank you. So, I'm really pleased to be back here in the great city of Glasgow. We have deep and cherished roots in Scotland, not least through Bank of Scotland.
Stand down.
Thank you, madam. Thank you, sirs. Please leave this with the stewards, with our shareholders. And I'm glad to see... I think, please, if other shareholders could stay seated, I think that would be the right thing. Leave it with the stewards who are trained to deal with these sorts of issues. With over 2.2 million shareholders, we have more individual investors than almost any other UK business. Many of those shareholders are among our 27 million customers, which gives a sense of the scale of the role we play in UK financial services. Madam, I think we really need to move on to the business of the meeting, if that's all right. Once again, I will have to ask the stewards to remove you from the meeting. Thank you. And in a short while, there will be a question and answer session. We will also hear from Amanda Mackenzie, the chair of our Responsible Business Committee. So, I'd like to begin by outlining a few changes to our board over the last 12 months. Alan Dickinson, having served over 9 years as a non-executive director, will be stepping down as deputy chair and as a non-executive director of the group. In September, we announced that Cathy Turner had succeeded Alan as senior independent director and also as chair of the Remuneration Committee. Alongside Alan, Lord Lupton will also be stepping down. I'm tempted to carry on, but I think you wouldn't be able to hear, so I'm not going to carry on. And I'm going to ask the stewards, again, please, unless you're prepared to sit down and wait for questions. Again on changes to the board. Alan Dickinson, having served over 9 years as a non-executive director, will be stepping down as deputy chair and a non-executive director of the group. In September, we announced that Cathy Turner had succeeded Alan as senior independent director and as chair of the Remuneration Committee. Alongside Alan, Lord Lupton will also be stepping down as a non-executive director of the group and as chair of Lloyds Bank Corporate Markets, following 7 years on the board. In February, we were pleased to announce the appointment of Nathan Bostock as a non-executive director of the group and, subject to regulatory approval, chair of Lloyds Bank Corporate Markets from the 1st of August 2024. Nathan was formerly chief executive of Santander UK and brings valuable experience and deep knowledge of the UK banking market, and reported a statutory profit after tax for the full year of £5.5 billion. More sustainable.
Mr. Charlie Nunn, does your £6 million salary not allow for Specsavers?
Sir.
Do you not see that Lloyds is funding the arms that are destroying people's future? Well,
sir, I think others have been through these issues before.
Lloyds is funding of weapons.
Sir, unless you allow us to continue with the meeting, I'm afraid once again we're going to have to ask the stewards to very carefully ask you to leave the meeting, sir.
You are partnering with the companies that thrive off harming others. How can this be? How can
sir,
you continue this?
The stewards, if you could cooperate with the stewards, that would be greatly appreciated.
Don't just focus on the shareholder profits.
Thank you,
Focus
sir.
on humanity. Focus on what makes us human.
Thank
that
you,
caring
sir.
for each
If
other
you could
should be the focus
please
of any bank.
leave the meeting.
You'll probably know who I am, Trevor Meelam of the Lloyds Bank Victims Group. I brought with me, I had quite an interesting read this week. It's the FCA document FG21/1, and it's the guidance for firms on their treatment of vulnerable customers. And I was actually looking not in this case for a Lloyds Bank customer, but a Shawbrook customer who could lose a £8 million portfolio, which is small time compared to many of the Lloyds. I'm wondering, I've been a Lloyds victim that I know of now for 14 years. And we know that Lloyds will conceal evidence, that sort of thing. I'm just wondering, is it time, Amanda, with vulnerability? And in this document, the FCA document, it does mention CPTSD. And a lot of our victims suffer from CPTSD. And the difference with CPTSD and PTSD, you can imagine a soldier on a battlefield and he sees a friend blown up or something, and that will haunt him quite a while. What the victims of Lloyds Bank, RBS, Commercial First, many of the other banks suffer, they suffer the constant letters from the lawyers coming through, the DLA Pipers, the Walker Morris, the TLTs. And I was in another one of your court cases just a couple of weeks ago. But I've come here today with questions from many. I've tried to amalgamate them. What I would like to know is, who is actually responsible for the vulnerability policy? I noticed that it was Catherine Rutter. Who would it be now? Or is there not anybody?
Again.
Who would it be now? Or is there not anybody?
Again, it wouldn't be appropriate in this forum to...
Well, it would be, Mr. Budenberg,
No,
because you trade with customers, and therefore vulnerability. See, what happens, a lot of customers get bad treatment and they get thrown straight to the lawyers, the sharks. They get thrown straight towards the snake pit.
I don't
and what
agree
they should,
with that.
well, I do, and I've got loads of them. And what should happen between the snake pit and the way they get treated, there should be an inner stage, Mr. Nunn. You're the CEO. There should be vulnerability. And the guidance is very, very clear from the FCA. We've thought the FCA are not that good, but their policy actually isn't bad, and the principles of business. The bits that I've condensed down to try and save you time, and obviously this has taken up 14 years of my life. We've lost many victims, many commit suicide. So far I'm aware of 70 attempts of suicide, and many of those are Lloyds Bank, and many of those are children. But we've got practices going on such as bait and switch. We've got consumer abuse, where there's unfair terms in consumer contracts, 1999. We've got bait and switch. I used to advise government. I used to advise HMRC, trading standards and so on. And you've also got bait and switch going on, which is consumer protection from unfair trading regulations 2008. You will be aware of risk and compliance. So it's very relevant, Mr. Budenberg, because when risk and compliance goes too far for profits, customers suffer. And that's where the vulnerability bit should come in, and you're not adhering to it. I've also been going out because it appears that victims are going to get no redress unless you're Noel Edmonds and you're a national treasure and you're paid and you go to New Zealand, or the Turners, or Joanne Dove, or some of the others that I could mention. Then the bank's lawyers, there's some of the worst, they just keep coming. I mean, I've been to court now as a litigant in person 24 times against your people. One of the names that comes up constantly, as in court the other day, when I asked Foot Anstey, who's driving this? And we know with the postmasters that a lot of it, money was just thrown at it by Paula Venables. The lady on your board there is Kate Cheetham, and her name comes up time and time again. Do you not think it's time that you actually said there are so many people complaining, such as this gent over here, that you should step back and say maybe these customers have got a point? So one of the other things that's happening, victims are getting no redress. The gentleman over here said about FOSS. Well, if you look at a lot of the Lloyds Bank employees, they come from FOSS, or vice versa. Or you'll get people from City of London police that cover bits up, such as Karen Baxter. And then she'll be at the FCA. So victims don't get redress from regulators, politicians, civil judges. Lord Denning said in 75 that if no one is above the law, and Lord Denning said that even if you get a civil judge who perverts a case, and I've been to a few of these kangaroo courts, they should be marched into a criminal court. We've also got police. We've got leaked police reports. I work with an ex-police lawyer. We work with many ex-CID and so on. But the other thing is, what is now happening, you see, you can control all that. And I'm sure the board has a good laugh at some of these victims. But there's a new movement happening, Mr. Budenberg, which this could all end. You're saying good things. Why don't you make them happen? You've got a horse on the wall here. I said last year, Black Bess, Dick Turpin. But I think the big elephant in the room is in Lloyds Bank itself. The new trend that's happening is, when I used to go to the government meetings, I was very good at finding the cracks in legislation. We're now using common law, we're using ancient law, we're using statute. And your court orders that you're getting, Mr. Budenberg.
Sir, there are other shareholders that want to ask questions.
And I've been fighting, and my family go through hell due to you lot.
I thank you for your support.
Thank you.
We're being fobbed off all the time. It.
Lloyds Bank will use the restraint of direct debits also to screw up customers' cash flow. They will then send them into court and asset strip them. That's another thing that's happening. But the movement that's happening, Mr. Budenberg, which you should be aware of, there are now teams around the UK. I go out as a witness to these teams. When all this goes to court, they want me there. And the situation is that when the bailiffs come along, if it's a normal residential property, they can't force entry. So your county court orders are no good. Your high court enforcement orders are no good. And one of the properties I went out to last week was an RBS one, and that was a mum with 4 kids. The youngest kid was 7. There were 30 people there to stop that happening. The bailiff on that one, I'm not going to mention him, but he's a thug. And there's a video out on the internet. One of our people then phoned the court. There was no paperwork, Mr. Budenberg. What had happened, the Wilson and Rowe, the bailiffs, had made their own paperwork up. It wasn't a court writ number, it was a made up one. And they were going to come along and take this lady and her 4 children's house for that. Now, this same bailiff, I've seen a group of guys twice get rid of him in Bristol. I've seen also he's been stopped in Surrey. You are employing companies that are employing thugs. I'm going to give you, the board, the benefit of the doubt that you don't know about it, but it's something you should pretty much look into, because people are losing their lives, their homes over this. You talk about setting it up for first-time buyers and that, but there are people losing their homes and their lives. I'm going to continue there because I've got a lot. I have got a list here, Mr. Budenberg. I have a list here, Mr. Budenberg.
If you would come to your question, please, sir.
These are, okay, my question is, I'm going to read some of these. These are near suicide cases.
Is this a question, sir?
The question is to your vulnerability director. Who is that on the board, Mr. Budenberg?
We have fully compliant
Who is
policies.
your vulnerability? Who is your
fully
compliance?
compliant policies for responsibility.
No.
I should just say to
you
all
have to have a vulnerability
Mr. Meadham,
officer.
We have looked into a lot of Mr. Meadham's concerns and not considered
and you cover them up.
We have not
Nick Johns,
covered them up, sir.
who saw the H-Boss Reading cases, that was closed after stage 4. It should have gone stage 5 to 8. And if you want to know some of the other people that should have been investigated, there's about 20 names in the Law Project Turnbull report. I know an awful lot. I know an awful lot of the people looking into bits. I get an awful lot of people come to me. But Mr. Budenberg, yes, Mr. Budenberg, what I've asked you, no, because they cover up for you. Well, I'm afraid they do.
They don't.
Well, I'm afraid they do. The police, the regulators, the FCA. What I've asked you, no, because they cover up for you. Well, I'm afraid they do.
They don't.
Well, I'm afraid they do. The police, the regulators, the FCA, they do. And I've been to enough. I've been to enough kangaroo courts that you guys, Joe, you go along,
I assure
and
you,
there's
sir,
no name on the listings board.
The FOS holders
I can
very
assure you
firmly
they do.
account.
And if anybody wants the evidence, I've got it. We gave it to you, Mr. Budenberg. But who is your vulnerability director? Who is it?
We have established policies
Who
and
is your
procedures.
risk
We
and
do not
compliance?
have
Who
a
is your
vulnerability
risk and
director on the
compliance? Who is your risk
We
and
do not
compliance?
have. Sir,
You have
please.
to have 3 lines of defence, and that stops at the board. Buck stops with you and Mr. Nunn.
It stops with me, sir.
Right, who is your vulnerability
It
director?
stops with me, sir.
Who replaced
Catherine Rutter.
Catherine Rutter?
I'm not going to start talking about names.
No, you're not, because it's not convenient,
is
it?
inappropriate, sir. It's
It's not
inappropriate.
convenient for you. Who's your risk and compliance?
Please, will you allow other shareholders to ask their questions?
I'm asking on behalf of many. What you guys are doing is criminal. You've got 2006 Fraud Act. I could quote you the sections, but I can't be bothered. You've got the Bribery and Forgery Act. Counterfeit Forgery Act, 1981. When that bailiff come along the other day, they created it. That's section 1. That's the creation of a false instrument. The holding of it, you've got section 2, 3, 4. You've got the intention to use it to private property. Fraud is basically party A deceives party B for party A's gain, party B's loss. Don't need to read it. You then bring in the mens rea, the actus rea. The property concerned is money, intellectual chattels, etc. Who is your compliance director? Who is your vulnerability director? Let them answer, Mr. Budenberg.
So
Who are they?
I've already answered you, sir.
You've answered that you're not answering. I will read these. Here's one. A Lloyds BSU victim of banking, hidden agendas, resulting in loss of 700 portfolio properties. You will probably know that. I'm not going to mention the person. There are serious discrepancies on this.
Thank you, sir. We've had 15 minutes. I think it's time we moved on to another question.
No,
Thank you.
Mr. Budenberg,
Thank you.
answer your question. You earn the big bucks, you answer the question.
I'm not sure what the question is.
Who's your vulnerability director?
I am responsible for what goes on in this bank.
Okay. So what about this? You're responsible for this, are you? So we've now got it.
So
that you
if
are responsible
please,
for vulnerability.
If you've got anything you want us to look at, please pass it on to the stewards.
We
Now
want you to look at the criminality.
To the next question.
We want you to look at the criminality.
I get to go on to the next question, please.
Right.
Thank you. Thank you.
The next question.
To B.
The next question. Julia Ottram will not be here.
Okay.
Due to medical reasons.
If we turn the camera on, this is clearly a different subject.
And her children are victims of H-Boss shredding fraud.
People lost their houses, they lost everything. People who were running successful business were out on the street. These people are not trustworthy.
One gentleman and 2 men posing as bailiffs crowbarred the door off and just burst into the house. They then said that the children had to leave the house. They threw them into the street and told my children in their bedclothes that they couldn't go back into their own home.
Oh my God. Why are they doing this? They're evil.
Shredding fraud. Why don't we have it out in the open, Mr. Budenberg? Let's have it out in the open. Why don't you run an ethical, honest bank? Because you're not doing that. Why is Kate Cheetham throwing money after money without stepping back
I'm not
and
going
saying,
to respond to that, sir.
so any question of value you don't want to respond to, do you?
Sir,
Let's have a board that can actually be transparent.
Not a question of value.
Well, a question of value is, why are you doing fraud on customers?
If we're not moving on to the next question, we'll move on to the next question over here. Thank you. If we turn that microphone off, please. Thank you.
So Julia and her children
Thank you. At level B.
I'd rather not be drowned out.
He won't talk until the A is finished. He's not going to interrupt the other shareholders.
Still want my question to be drowned out.
I'm sorry?
I don't want my question to be drowned out.
After they were kicked out, his assets stripped by PwC, being shot up again. Their home of 20 years was stolen by thugs and bailiffs. Again, it's all on video. We used unlawful tools. Police in Sussex, police found to uphold the law and human rights, and a regular judge on many of the Lloyds cases appears a vulnerable family whose land is only to close on their back. This bank is doing fraud. Kate Cheetham is the tool of vendors. She bought money of it. She destroys lives. The bank has full knowledge of...
Sir, I have asked you to either ask a question which is a question relevant to the purpose of this meeting. Thank you. Yes.
When Juliet was really upset,
I'm here at B.
Her son turned around and said,
Okay, Joe, do you want me to do that? Okay, make B live.
So I'm very sorry to hear of these distressing stories, but we need to move on with the business of the meeting.
Okay, I'm ready to make an announcement when you need. Just need.
Thank you, sir. Thank you, sir.
Obviously, the reason these frauds are happening, she don't know.
Thank you, sir.
Go, Liam.
Next question from stand B.
Good morning, or good afternoon now. My name's Paul Carlier, former employee of Lloyds. In 2022, I obtained new evidence and made new whistleblower disclosures to you personally, Mr. Nunn, specific to that evidence and allegations that the evidence proves your bank, my former employer, took a decision on or around 19th of March 2015 to unlawfully conceal from me, from shareholders, including those in the room today, and the Employment Tribunal, the substantial losses incurred by a rogue trader at Lloyds in January 2015, and conceal the findings of an internal Lloyds investigation, and to conceal the decision to sack that rogue trader and his manager, and instead allow them both to walk away scot-free and undamaged, and with the demonstrable intent to pervert justice and cause substantial financial and reputational detriment to me in employment tribunal proceedings that were in train at that time. Me, being the whistleblower who on 14th of March 2014 had discovered and blown the whistle on the rogue traders, and I quote, insane and reckless risk-taking, and their actions taken to falsely represent the true risk and conceal it, and where I warned of the substantial losses this gross misconduct or unlawful behaviour exposed the bank to, all of which was realised in that January 2015 and after I was unfairly dismissed. The bank knew it was impossible to defeat the whistleblower elements of my claim if they disclosed to me in the tribunal the huge losses of that rogue trader as a result of the conduct about which I had made whistleblower disclosures. and the decision to sack them and the manager. The manager was the bank's principal witness at those legal proceedings in 2015. You, Mr. Nunn, promised me that you were investigating these new disclosures that I made to you in 2022 and would produce a comprehensive response no later than the 17th of May 2023. You breached that promise, so you can fulfil it now and provide the response to these allegations made within those new whistleblower disclosures here and now. Shareholders have a right to know about conduct by that rogue trader that could have brought down the bank and wiped them out, and why you personally are continuing efforts to conceal it and your apparent willingness to further the abuse of a whistleblower and protect the guilty rogues whose conduct jeopardised this bank and its shareholders. Personally, guaranteed me a response that they were investigating these new disclosures based upon this new evidence and would provide a response to me as per the obligations under FCA codes and applicable law. And that response was not forthcoming. I've got the email that says I was going to be receiving this response by 17th of May last year, the day prior to the AGM, and it was never delivered. So did the bank conceal those losses from these shareholders, the 15 million in losses that could have easily been 5 billion, 10 billion, 15 billion? And did they conceal the findings of that internal investigation and conceal the decision to sack that rogue trader and his boss so as to pervert the course of justice at that 2015 proceedings? There is no other reason to conceal those findings.
Again, it is not appropriate in this forum to go into the details of something that happened in 2015 and which is clearly a personal matter.
No, it's not a personal matter. Every shareholder in this room was exposed. This is the same conduct. This trader was up to the same conduct that AIG was up to. He was selling copious amounts of high-risk derivatives to get in some premium, okay, and they exposed the bank to substantial losses.
In which case, I'm sure that the regulators looked into it very carefully at the time.
So you're saying that the bank has not investigated that new evidence?
I'm not saying that at all, sir. I'm saying that unless you have new evidence...
I gave the new evidence to Rob...
a regular correspondence with you, sir.
No, I gave the bank, and Charlie Nunn personally, and Charlie, you're responsible under senior manager's regime to investigate these things. You in writing, or your office in writing on your personal behalf, promised me a response that you're investigating this new evidence, promised me a response, and you haven't delivered it. So...
I'm sure that the organisation did what was appropriate.
Sorry.
This man has asked you something because you report it not to the FCA, but to the NCA.
Sorry. So you're saying that Charlie Nunn, the CEO, can promise me that he's investigating this new evidence, promise me a response, and then simply not deliver it?
I am saying, sir, that we have been in correspondence with you about this, and we are not going to agree on this. It's something that happened quite a few years ago. It's something that the FCA, I'm sure, has looked into.
Yes, actually, on that point, the PRA took regulatory action against Lloyds in 2015 specific to this, but the PRA, the FCA and the bank chose to conceal that regulatory action as well, and conceal that from shareholders. Have you got anything to say on that?
I don't have anything to say on that.
So Charlie Nunn is not going to provide the response that he promised me?
I've given you my response, which is that we have responded to you over the years on this matter.
You haven't done.
And there is no merit in going into it further in this forum.
So the 50 million lost by that rogue trader...
So I think you had another question?
Yeah, I do, but the 50 million lost by that rogue trader is irrelevant to shareholders in this room. Can you confirm that that money was lost by that rogue trader in 2015?
I'm not going to confirm anything from 2015.
I know you're trying to make this look like a legacy issue, but it's only a legacy issue. It fails to be a legacy issue if you're given evidence under your regime and then you ignore it, and you're just furthering the concealment and the unlawful conduct that was a legacy issue.
Can we go on to your second question, sir?
Okay, so for the record, you're not going to provide the response I was promised.
If we can go on to your second question.
Well, no, answer this first. You're saying here and now that you're not going to provide the response that Charlie Nunn promised me last year, specific to this new evidence, about wrongdoing that could have wiped out every shareholder in this room?
I am saying we have been in regular correspondence with you, and we do not agree with the nature of your assertions. So if we can move on.
But you haven't provided a response, Mr. Budenberg.
Please, if you can move on to your second question.
If Charlie Nunn writes to me promising me that they're being investigated, promises me a response, how can you say that you've corresponded when you haven't provided that response?
My understanding is that there has been regular correspondence with you over many years on this matter.
No, there hasn't, because I only raised this issue with Mr. Nunn in 2022, and there has been no response.
Answer his question and you move on.
This is a whistleblowing issue. This is about conduct.
If it's a whistleblowing issue, sir, it's not appropriate to talk about it in this room.
It is, because every shareholder in this room could have been wiped out in 2015. And if you're concealing it now, what's to say that you've got measures in place to make sure it doesn't happen again? If you're prepared to conceal this now, are you going to conceal this from shareholders in the future as well?
Sir, our regulators take a very serious view of these issues. If they were concerned, something would have been done.
Yeah, they did. They took regulatory action against you, the bank, but then you, the bank and the regulator concealed that regulatory action from me, the shareholders and the public in 2015. And you concealed it from the Employment Tribunal in 2015, despite it being relevant evidence to that case.
But so go on to your second question, sir.
Answer the man. You've got a fiduciary duty to every shareholder here. Answer the questions or resign.
Mr. Medium, you've had your opportunity to ask questions. Thank you.
Or resign.
I will not resign.
No, you
Carry on, Mr. Carlier.
You're running a crooked bank. Answer the man's questions.
Mr. Carlier.
Well, no, I just want the response. Or will Charlie Nunn at least agree to provide the response in writing to me that he promised me by 17th of May last year?
We will review the correspondence and come back to you.
Right, okay, I'll accept that. Right, my second question, again to you, Mr. Budenberg and Mr. Nunn. The bank has recently made provision of only 450 million for its potential costs or liabilities resulting from car finance mis-selling and or fraud. By my calculations, and I was the one who first reported this to the FCA in February 2016, after Black Horse lied to me in a complaint response, the bank will actually incur costs totalling a minimum of 2.5 billion specific to the car finance scandal, and a minimum of £4 billion if it is determined that the bank should repay every penny in interest paid by the victims as opposed to just a part of the interest. For the record, this being made up of legal costs, administrative costs and compensation the bank will be liable for. You must know this. You must know that this is the true minimum. So do you agree that you have misled shareholders by only making provision for 450 million, which had the effect of manipulating the share price higher? And will you resign and return all bonuses received since you signed off on this lowball provision if the true costs are materialised and they do indeed exceed a minimum of 2.5 billion as I've suggested here today?
We understand this is a serious issue of concern obviously to us as a board and to all shareholders, quite rightfully. This is a process that is very early in its unfolding, and in March of this year we were the first business to make a provision in regard to motor finance. I should say that motor finance is a very important part of our business and part of helping Britain prosper, because it's a fundamental way which allows people to buy new cars. So this is not a, if you like, a shady part of what goes on in the UK economy. It's a very important thing, and it's why we do it. We obviously at the time made what we are required to do under accounting standards is to make the best possible provision that we can and the best possible estimate of that. We made it clear that that estimate could go up or it could go down over the course of the investigation. The FCA has intervened, for which we think is a good outcome from our shareholders' perspective, because we want to get to a clear outcome as soon as we can. So we've made it clear that we've made the best possible estimate of the liability that we can, and we have also made it clear that that could turn out to be right or wrong, and it could be too big, too small.
You can't seriously believe that your total liabilities are going to be anywhere close to 450 million. I mean, the administrative costs and legal costs alone will exceed that by some margin. You know, and let's not forget as well that the bank, along with Santander and Motor Novo, are facing a claim at the Competition Appeal Tribunal as well, where the damage is being sought there over 300 million. The legal cost to deal with that, you clearly haven't factored that into it.
We have included an estimate of the legal costs of this process in that. But again, that could turn out to be right or wrong.
But this is a process that dates back to 2007, and looking at cases back to 2007, Black Horse was the market leader in car finance and made that boast on many occasions. I think in 1 year at least, it claimed 40% market share. And just to give you an example, for 12 months prior to May 2019, 17 billion in used car finance was issued. So, you know, if you've got a 40% stake in that, but most of it was missold. In fact, all of it was missold because I've got the evidence to prove that Black Horse missold and lied to customers as well. Your costs are going to, and your liabilities and compensation is going to be a significant multiple of 450 million. You have to know that.
We believe we complied with relevant regulation throughout that period.
Okay, well, if I'm right and you're wrong, and these liabilities and costs and compensation does exceed 2.5 billion, will you accept that you're wrong and these provisions were wholly wrong and you resign as a result?
I will not resign as a result. We've made it absolutely clear that these provisions could be right, they could be too big, they could be too small.
No,
we have complied with all the regulatory accounting standards. We've given our auditors all the necessary information. Our audit committee under Sarah Legg has been through this issue very carefully. This is an uncertain process. Nobody can say exactly what the outcome is going to be. We wanted to make clear that we flagged that the potential outcome was significant, and we felt at the time that 450 million was and still is the best possible estimate that we can make at this point in time. We will have better information as we go forward through the process, and I will make sure that shareholders are kept up to speed.
Okay, but you're ignoring the PPI scenario as well, where how much did you originally make provision for there?
We don't see this as the same as PPI.
It won't be the same. It won't be the same in terms of the eventual quantum of damages paid, but you are going to have to pay back a substantial part of the interest that customers have paid since 2007, if not all of it, depending on whether or not plevin is applied or how the FCA deals with this.
That is not yet clear and will depend on a view that the FCA and various advisors to the FCA are undertaking at the moment.
But if the FCA doesn't do anything, there are class actions in train, not just the Competition Appeal Tribunal, but other class actions involved as well, whereby if there are any shortfalls in terms of the FCA's remedy in distress or redress, these class actions will pick up that mantle and ensure that customers get the true shortfall. So there are no circumstances under which your costs or your liabilities are going to be less than 2.5 million. You have to know that. That is extraordinary.
Keep shareholders informed as this process unfolds and as we get better information on which to make, as I say, different provisions if that is considered to be necessary. Thanks.
Okay, I'll leave it there. Prior to the meeting, I did submit 4 questions in writing. I'm going to yield for somebody else right now, but would the board commit to answering those 4 questions that I submitted in writing, replying to me in writing after the meeting?
Yes, we will. Thank you. Thank you, Mr. Carlier.
Disaster. The APPG said it was a total disaster. It cost £40 million. Not long after set up, a lot of some would perhaps call them criminal, I don't know, but there are people that appeared on the board of the BBRS that have been involved in the failure and collapse of some of the customers' businesses. So I'd like your views on the BBRS. Was it fair? And if not, which the APPG said it wasn't and everybody else, what are you going to do for the customers who didn't get a fair deal? The other question I've got, this was perhaps nudged to me by Anthony Stansfield, a name you'll know well. We're not hearing much about the Dobbs review lately. How much has it cost? Will there be a interim report, and when will it be complete? And will Lloyds be releasing it, not heavily redacted, to the public in this lovely new wave of being transparent? Mr. Budenberg, there's your questions.
Thank you, Mr. Medium. The answer to the first question is that, as you say, the BBRS looks as if it will be discontinued, although it's carrying on until the end of this year. The reality is that there was actually very little demand for it, for whatever reason that happens to be. And we will continue to offer support to our small business customers through our existing complaint system.
Mr. Budenberg, there was a need for thousands of customers that were collapsed and lost everything. So there was a need, but it failed. Parliament said it failed. The APPG said it failed. So what are you going to do about it?
The BBRS is something that is under discussion with regulators, with, as you say, parliamentarians.
Why is it not including talks with the victims, the people that were affected?
As I say, very few people actually applied to the BBRS.
Well, I believe, Paul, have you got the figures on the BBRS? There was hundreds though, wasn't there? There were hundreds of customers and there was a handful that got any remedy, and I think that was peanuts. It seems that Lloyds Bank are more interested in pouring money into covering things up than they are to doing the right thing, the ethical thing.
As I say, the BBRS is not our responsibility, it is an independent
No, but the
body.
staff who done damage to the customers, the staff that done damage to the customers is your responsibility. The 3 lines of defence brings it right back to you and Mr. Nunn.
And we do have a complaint system that people on the corporate side use on a regular basis.
And it doesn't work.
That's your opinion, sir.
It's my opinion, and it's the opinion of a lot of the victims. What about the Dobbs review?
Question, sir.
The Dobbs review. So for a bank that doesn't seem to do a lot wrong, the Dobbs review has now been on the go for 7 years, which is handy to take it past the statute of limitations. But as in the Supreme Court case in November last year, Potter, new evidence can be introduced, and obviously fraud is not time barred. So what has been spent of the shareholders' potential income to do the Dobbs review? Is it $500 million?
I'm not going to go into the details of the cost. The Dobbs review was deliberately set up as a totally independent review,
but it was commissioned by you guys, and
was commissioned by us as an independent review, and we have no influence over that. Any questions in relation to the Dame Linda Dobbs review should be addressed to the Dame Linda Dobbs review.
Will the information be made publicly available, and when will that be? And at 7 years, isn't it time that there's an interim report?
That is a question for the Dame Linda Dobbs review.
Well, surely you're the paymasters. If I was paying something, I'd want some answers. You've been paying for this. Adam Wiseman's an expensive KC. He's a criminal KC. You're putting criminal judges and KCs on it. You try and then, you then make these things civil, and you go past time barring.
We felt it was very important that the review was done in a totally independent way. I think that's what you would expect.
But we got victims dying.
Again, if you have any issues about the Dame Linda Dobbs review, you should take them up directly with the review.
What about taking them up with the chairman and the CEO of the bank and Amanda Mackenzie, which is the nearest I can see to a vulnerability?
The review is completely independent.
You didn't even know the timescale of direct debits, which I find hysterical.
I don't think that's directly relevant.
Well, I think it's very relevant because you're bankers.
Thank you. I think Mr. Murray wants to ask another question.
Well, you haven't answered on the Dobbs review.
I have, sir.
When is it going to be done?
Any questions in relation?
When is it going? I'm a shareholder. When is the Dobbs review? Because when a lot of money goes out, these guys' shares are going to plummet. When is the Dobbs review due?
The Dobbs. You will have to ask that question to the Dobbs review, as I've said 3 or 4 times already.
Pathetic.
Thank you.
Absolutely pathetic.
Thank you, sir. Mr. Murray. Mr. Murray.
So, Dobbs review. If these are supposed to be civil instances, legalese
this question.
Legalese is 6 years. Legalese is 6 years. You are denying customers remedy. A lot of these are put out on the street. I've seen the bailiff's paperwork where they've made it up. It's fraud all the way through. You're running a fraud game. This is mafia, Mr. Budenberg.
Mr. Murray.
Chairman, thank you for letting me back in. I've had time to reflect on what we discussed earlier. I still think you're being very unfair and unreasonable in not allowing me access to a director with all the points, major points that I've made to you. You don't seem to have responded to my comments on the delays in replying to the Financial Ombudsman Service. You just seem to have ignored that. I feel very fobbed off. I would like to meet with a director, please, because these are important issues. And if that doesn't happen, this is so similar, but not to the same extent, as the post office abhorrent scandal. You've got to talk to people. You've got to allow them a fair hearing and not put up the shutters every time somebody asks a question or protests.
Thank you, sir. We are not putting the shutters up. We are saying
give me a director,
we have
please.
a customer reception downstairs, and that's where it is absolutely appropriate for these issues to be raised, not in a public forum like this. And
will they allow me to take it on then?
It is unfair on other shareholders, on other customers, if we give preferential treatment. So it's important that all our customers get treated in the same respectful way. Thank you, sir. Thank you. Okay. So now we've come to the end of the question and answer session, and I'm about to close the voting. Please register any votes.